I mispronounce your name every time, sir.
It's okay.
I apologize.
Thank you, Your Honor. Today is the time and date set for a probable cause conference. Regarding that, we are asking for
This case, while the man violates bond, blames O'Dowell's sin, spirals under pressure. But was it just fear or a full-blown lie? Watch closely. The judge doesn't hold back, and this hearing quickly turns into a brutal truth test. Buckle up, it gets tense, fast.
alcohol on July 7th.
And I'll accept that. Before imposing any sentence regarding that.
This case, while the man violates bond, blames O'Dowell's and spirals under pressure. But was it just fear or a full-blown lie? Watch closely. The judge doesn't hold back, and this hearing quickly turns into a brutal truth test. Buckle up, it gets tense, fast.
So my only question is does your client wish to stick to that story, or does he wish to tell me the truth?
I believe that he would not be sticking to that story, that he would be stating that he consumed beer.
That's correct, Your Honor.
Then why'd you tell everybody O'Doul?
I had O'Doul's first, but I needed beer.
You had O'Doul?
Yeah. I don't look like what I'm going through.
No.
I had O'Doul's.
Are you
I had
tell me that? So did you tell them that?
Yes.
That you had O'Doul's first and then had beer?
Maybe I omitted the beers, but yes.
What?
I omitted the beers.
Hold it. You know what, sir? Don't play fast and loose.
I got
The
it.
story.
Boom, there it is. I omitted the beers. That's not honesty. It's strategic silence. The judge sees right through it. Saying less to avoid trouble in court, that's as bad as lying. Would you call that a mistake or a calculated move?
You even have an O'Doul's that day?
Yes.
How many?
6.
And then how many beers?
2.
So why didn't you tell them that you had the beer?
I just omitted.
Pardon?
I just didn't. I was afraid of what might happen. I thought I could pass.
Yeah, I would be too, because you're violating your bond condition.
Indeed.
So, first of all, we did the calculation because the only story you gave is that you had O'Doul's. To get to the level that you were at, you would have had to have 25 O'Doul's in an hour.
No, I didn't have
in
that.
order to reach that level,
Sure.
and could not have used the bathroom because you couldn't eliminate in order to get to that.
25 O'Dowell less in an hour. Come on. The judge uses logic to destroy the excuse, that much alcohol from non-alcoholic beer. Impossible. This isn't just sarcasm, it's courtroom checkmate. Credibility. Gone.
Bring yourself to say that you were intentionally lying to them and attempting to mislead them. It was not just a simple omission. Counsel, what did you want me to do with this case?
Regarding the probable cause conference, we're asking for a 2-week adjournment so that he can show that he's going to comply with the court's orders.
Well, I don't think he's going to have a choice on that, quite frankly, Mr. Allen.
We are asking for him to remain out of custody today. This would be his first bond violation. He is here to be on.
The defense wants mercy calls, this a first-time slip, asks for rehab. But honesty is the real issue here. Can a man who hides the truth be trusted with freedom? What do you think should he walk out today?
Asking the question of why didn't he tell them? And he couldn't even be honest about that. I'll let you go ahead with your argument, but I'm not buying any of that.
Your Honor, he is honest about the fact that he consumed alcohol, and he is very open to treatment. He understands that he has a substance issue and he wants to get help for that. Your Honor, he's a business owner. There's a lot of pressure on him. He provides for himself and his family. He also does volunteer work, not court ordered, just out of the goodness of his heart. He is open to treatment, substance abuse, counseling. He plans to seek that regardless of whether the court orders it or not. We're asking you to keep him out of custody with a SCRAM tether. Again, this would be his first violation. And he is asking for the opportunity to show compliance while out of custody.
Anything from the people?
Your Honor, we do have concern about Mr. Johnson's ability to comply with the bond conditions. As stated, this is his second offense. I think it's just a couple of years.
Now, it escalates. The prosecution brings up past offenses and guns. This isn't just about alcohol anymore, it's about danger. Can someone who hides beers be trusted with weapons? That's a serious red flag.
So we do have some concerns about whether he's able to comply with those bond conditions.
Anything else?
Your Honor, I just think that he would have a better opportunity to get the treatment and help that he needs out of custody.
He first has to admit that he has a problem.
I
The
do.
way that he does admit that is he stops lying. Defendant's bond at this time is revoked. Defendant's remanded.
He has to stop lying. That one line says it all. The court won't help someone who won't help himself. Treatment can wait. Truth comes first. Bond revoked. The lie cost him everything. This case proves one omission can derail it all. Like, comment your thoughts, and subscribe for more intense courtroom moments right here on Court Cases.
Court does call the case, People versus Fred Willis.
When you're going to go to the people.
And Alex Warren Green on behalf of Mr. Willis.